Hi everyone, my name is Donna. I'm an associate at Chamberlains Law Firm, and today I will be talking about deceased estate administration, the basic. So the purpose of this talk today is just to give you the basic information about deceased estate and the administration process. So deceased estate administration is the process after someone passes away. When someone passes away, there's a process involved in dealing with their assets and their affairs, and we collectively refer to that as deceased administration. So I'll start off first just to go through some definitions to explain to you that, so that you understand throughout this talk, when I refer to executors or administrators, you know what they mean. So executor is the person appointed to manage a deceased estate, and they're often appointed in the will. An administrator is a person who is appointed by the court to manage a deceased estate. The testator, the term testator means the person who made the will, and beneficiary or beneficiaries are the people who are set to inherit the estate or benefit from the estate. Often I get asked a lot of questions about deceased estate, what do I have to do, and what the process is, and I generally tell my clients that there are often two stages. The first stage is to obtain a grant of representation, or a grant of representation is either a grant of probate or a grant of letters of administration. And the second stage is the administration process. So the second stage is, often people refer to the two stages interchangeably like they're the same thing, but there are actually different processes. So grant of representation, there are three most common grants of representations. The most common one that people are familiar with is a grant of probate, and then there's also letters of administration, a grant of letters of administration, and a grant of letters of administration with the will annexed. So a grant of letters of administration is obtained when someone has passed away without a will, and they have passed away what we refer to as they died intestate. A grant of letters of administration with the will annexed is when there is a will, but the appointment of the executor is invalid, or the executor has passed away or was unable or unwilling to act as the executor. And the third one, which I've mentioned previously, is the grant of probate. Probate is obtained when there is a valid will validly appointing an executor. So the executor would often apply for a grant of probate, and probate itself means proving the will. So it's a process of proving the will through the Supreme Court of the relevant jurisdiction. It's important to note that the laws regarding deceased estate and the administration of deceased estate is governed by each state and territory, so they have their own laws. They're all very similar, but the processes are a little different, so it's important to remember that and keep that in mind. And what jurisdiction or what state or territory you make that application for the grant in will depend on where the assets are situated. Probate comes from a Latin word to prove, hence to prove the will. Now, it's a process, like I mentioned, through the Supreme Court. It is a 4 to 8 week process from the day that you get the death certificate. It's done through the Supreme Court because not all wills are valid wills. So, and that process is done to ensure that the executor makes the application for the grant of probate. As part of that process, they are proving that the will is a valid will, that it's executed in accordance with the Wills Act, that they are the executor in the will, and that they will comply with their duties and obligations as the executor and administer the estate appropriately and distribute the estate in accordance with the will. Now, that's if somebody has left behind the will and we go through the process of obtaining a grant of probate. Once you have the grant of probate process itself, once that's complete, you get issued with a document from the Supreme Court to say that the executor has proven the will and probate is now granted to that person, and that person now has the legal rights and authority to deal with the assets of the deceased. Letters of administration, which is the other common grant of representation that often you have to apply for as part of the administration of a deceased estate is someone applying to the court to be appointed the administrator, and the administrator then has the right to manage the estate or the assets of the deceased. And that person is appointed by the court as opposed to an executor who was appointed by the deceased in their will. A lot of people do ask, what do I have to do other than apply for gradual probate? And I say, what you need to do and what is involved in the process really depends on what kind of assets the deceased left behind, whether it's because the assets will determine what you have to do and how you proceed. What I have here with me is a little picture of a tree. So I decided to print out this little picture as kind of like an analogy to kind of explain that the tree branches is like the affairs and the administration of the estate. It can branch out to a number of branches, and it can go in all sorts of directions. It really depends on how organised the deceased was and how they managed their affairs and what kind of assets they left behind. Yeah. Another consideration is I often get asked a lot is what's involved. So I've gone through what's involved, and what's involved depends on the assets. So, but the first thing that people often should do is to ascertain if there is a will, and then ascertain what kind of assets there are. Because, like I previously mentioned, it will determine what the executor or what an administrator or interested party will have to do in relation to the estate. There are laws that regulate the administration of the estate, and it is important to be familiar with those laws. The most common is the Administration of Probate Act of each jurisdiction, or the Succession Act. Some states it's called the Probate Administration Act, some states it's called the Succession Act. So we just need to be familiar with the relevant legislation, and that's the most common one. But depending on, again, the assets of the estate, there may be other legislation that you need to be familiar with as well, such as the Trustee Act, the Wills Act, and depending on the affairs of the beneficiaries or the executors, you might need to be familiar with the Bankruptcy Act or the Corporations Act, or even the Superannuation Act. One of the things that I like to talk about is the duties of the executor. So the executor and the administrator. So it's important to remember that executor and administrator are just terms to identify how this person has attained the authority to deal with the estate. The executor and the administrator, they have the same role and they have the same duties and obligation and responsibility. As previously mentioned, one's just appointed in the will and one's appointed by the court. So throughout this talk, when I'm talking about executor or administrator, I'm referring to the same person, the person who has authority to deal with the estate and to make decisions and to sign documents and to give instructions to third parties. One of the things that people need to be aware of as the duties and the obligations of an executor or administrator is to, so I've got my notes here, is to apply for grants if necessary. Now, I say it's necessary because depending again on the estate, the size and the assets of the estate, you may not necessarily have to obtain a grant from the Supreme Court. So some estates, particularly small estates, we refer to small estates as estates where there are, not a significant amount of assets. If they're small, you don't necessarily have to obtain a grant to administer the estate. Most organisations and most institutions will accept a will to take instructions from the executor. That cuts out the first step of the whole deceased estate administration process itself. The second step, which is the administration side, must be done regardless of whether someone has left behind a will or not, and whether or not you obtain a grant of probate, because there are still assets and accounts and affairs such as tax returns that need to be finalised when someone passes away. Some of the general duties of an executor is to identify and secure the assets of the deceased, value the assets. You need to obtain a valuation of the assets in order to account for the beneficiaries or the court if you are to, call in, sell and convert the assets, cancel any direct debits or subscriptions, finalise any paperwork and any other affairs that the deceased might have, such as, subscriptions to newspapers or any memberships that they might have. And most importantly, notify the ATO as well. So their role is also to notify the ATO, interested or relevant parties, to liaise with beneficiaries and asset holders, keep them fully informed and of what's happening and the matter, and obtain appropriate advice when necessary. Now that's an important factor to remember. As the executor or the administrator, you are responsible for looking after all the assets and making sure that the deceased estate is managed and dealt with accordingly. And you have an overarching obligation towards the beneficiaries. So as part of your duty and role and administering the estate, you're required to act in the best interest of the beneficiaries and to maximise the estate for the beneficiaries. And that may involve obtaining appropriate legal advice to make sure that you know what you can and cannot do as the executive administrator, what you should and should not do. And if you receive a request for a beneficiary wanting to do something, how you would do that to protect yourself as the executor or the administrator. It's important to remember that the executor and as the executive or administrator, you have a lot of obligations and responsibility because you are managing often a large amount of assets or money on behalf of another person. So you have to make sure that you act appropriately and seek the appropriate advice, because you will be asked, held accountable and asked to account to the beneficiaries as to why you've done certain things, what you've done, and when you've done them. And if you have sought them the appropriate advice, whether it's legal advice, financial advice, or taxation advice, you are protected by the legislation in managing your role. But that's if you acted appropriately and sought the relevant advice. One of the things to remember is that when with an administrator, that the administrator makes an application to the court to be appointed the administrator to manage the estate, and then once the court is satisfied, they issue the grant of letters of administration to the administrator. So that's a voluntary step that the administrator would do. A lot of people don't realise that when you're appointed an executor in a will, that you don't have to take on your appointment as the executor. So just because someone appoints you as the executor of their will, you don't have to take on that appointment. So it's very important that if you're ever appointed an executor of a will, the first thing that you should do is to seek legal advice. Because if you don't want to be the executor, you must act as soon as possible. Because once you start acting as the executor, taking on the role and doing things that an executor usually do, it's really hard for you to then say, no, I don't want to be the executor anymore. And it's even more difficult once you've gone through the process of proving the will and obtaining a grant of probate. Often after that process, you will require consent from the court to exit that office as the executor of the estate. Another thing that I often get asked by clients is, how long does all this take? And how long everything takes really depends, again, on whether the deceased left behind a will, whether what kind of assets there are. So sometimes there could be complex assets that need to be dealt with, there need to be assets that need to be located. It really depends on how well the deceased has left behind instructions and how they have managed their affairs. So going back to the tree that I had previously, I like to align with like the trunk is the granted burden of administration, and the root system is kind of like your estate planning, the deceased's estate planning. So what kind of seed they plant as part of their estate planning will determine what kind of tree they end up with, whether they end up with a tree with a lot of branches, which is very complex and can go in an array of directions, or if they were very organised and they're organised and prepared and did their estate planning well, then they might end up with a tree like this, which is very simple and straightforward. You've got the straight trunk and then the top part is the beneficiary, so you don't have a lot of branches and branches where the estate could turn in any direction. They can go in a variety of directions, which can make the administration of the estate complex and take a lot longer. But my general rule is that if you're an executor, the administration of the estate, don't expect it to be completed within 3 months. It's a minimum of 3 months because you do need to wait to get the death certificate before you can make an application for a grant of representation. And my screen's gone blank, but anyway, my screen's gone blank. To obtain a grant of representation, and the death certificate can take anywhere between 2 to 8 weeks, depending on the jurisdiction you're in order to receive the death certificate. And you need the death certificate before you can file your application for the grant. And then once you obtain it, once you file the application, you do then need to wait for it to be approved by the court. Now, applying for a grant, there is a process involved in that. You do need to advertise your intention to apply for a grant, and that advertisement needs to be up for at least 14 days before you can make your application. Now, the reason that you need to advertise and you do need to go through this whole process is that it gives people the opportunity to come forward with a later will. If you're relying on a particular will to obtain a grant of probate on that will, then it gives people an opportunity to come forward with a later will and say, no, I've actually got a later will that revokes this will. Or if you're applying for a grant of administration because someone's passed away without a will, that gives someone an opportunity to come forward and say, no, that person didn't die without a will, there is a will and I have that will. That is often the process because it's a guarantee by the court that you have gone through the appropriate process to be validly appointed and to prove the validity of the will. It gives asset holders that extra level of security. This is why a lot of banks or a lot of like the landholders office will require that you produce this grant of probate because they know you've gone through this process of proving the will and you've given the opportunity for other people to come forward if necessary. Now, often people would think that, administering the estate is quite simple, it's quite straightforward, and it can be, but it can also be very complex as well. Like I said, it's strongly advised and recommended that you seek appropriate legal advice so that you make sure that you're doing the right thing and that you're doing the right thing by the beneficiaries and so that there are no consequences that might revert back to you later on in the future. Now, some of the issues, depending on the estate, there are often issues that arise that are not litigious. So litigious matters are matters that have to be resolved through the court or resolved through as part of the court process. So the administration of the estate can often be complex and there may be issues that arise that require the executor or the administrator to seek appropriate legal advice. And these issues are often not litigious, where in a sense that you have to go through the court system in order to resolve them. The most common estate litigation or the litigious matters that people are often familiar with is like challenging, what they refer to as challenging the will. So to challenge a will, there are two ways you can challenge the will, and the legal terms is called challenging the validity of the will or making what's referred to as a family provision claim. The family provision claims are the most common types of challenges to a will, but I just want to emphasise that the purpose of this session today is not to talk about those two matters. The purpose of this session today is to talk about the administration itself. And the administration of the estate, which is the managing of the estate and finalising the affair, can take many years depending on the assets and the state of the affairs of the families when they passed away and what kind of instructions they left behind. You know, a number of issues can arise in administering an estate. So you might have a will, it's quite straightforward, it gives you instructions, but there are issues that could arise that often people don't realise, or the deceased don't realise until they pass away, because nobody looks at the will in detail until you pass away and the will has to be administered and you have to go through this process of administering the estate. Now, some of the issues that can often arise that may not necessarily be litigious issues are issues such as the interpretation of the will. So the will, you might read it and you might have an understanding of what it says, but if it's not appropriately drafted, there may be ambiguity as to what a particular term or a particular phrase means, and you would need to seek advice as to what the law has decided in relation to these matters previously. So that's why it's important that you get your will drafted by a professional and understand what it is that you're putting in your will, because your intentions may be one thing, but the way that you express it in the will is not appropriate, or it may not be clear for the people who are not there with you, and you're no longer there, the deceased is no longer around to explain that to you. So, and that's a good way to refer back to Angela Backhouse's presentation last week about preparing a will and what to do. So I won't go into that. Angela has done a very good job of that. So some of the other issues that an executor or administrator may face as part of the administration or managing a deceased estate is often matters of insolvent estates. So an estate can be insolvent, so not all estates have money that are available to distribute to beneficiaries. You can also have what to do when a beneficiary is bankrupt. You know, there are obligations that the executor needs to be aware of. There may be difficulties in dealing with beneficiaries, so you might have difficult beneficiaries, and you may need to seek advice as to how you deal with them and what your rights are and what their rights are. Difficulty in taking possession of assets, so you may be familiar with a particular asset of a deceased estate, but you can't take possession of it because someone is squatting in it or someone has the legal title to that property, and you need to get that back. Distinguishing estate assets and non-estate assets. So there are assets that do form part of your estate, and there are assets that don't form part of your estate or this estate. So this is often explained to the testator or the deceased when they're making their will, but it's not often explained to the executor. And this is where appropriate legal advice will come in for the executor and the administrator. So it's important to distinguish what forms part of the estate and what doesn't form part of the estate. The deceased assets, the estate assets that do form part of the estate are assets that are in the sole name of the deceased. Reimbursement of expenses paid. Often executors don't realise that they've incurred costs in relation to the estate, they can be reimbursed. Or if someone has incurred costs and they're seeking reimbursement of the estate, is that reimbursement allowed pursuant to the relevant legislation and the case law? Beneficiaries' entitlements and rights. It's important to remember that executors and administrators have different rights and obligations and duties and responsibilities to those of the beneficiary. So the beneficiaries do have a right, have certain rights and entitlements to be kept informed forms and to be given accounts and to be given updates and to be given a copy of documents. But it's the executor who has the right to make decisions and who has the right to sign off on documents and to give instructions and engage other people to assist them in administering the estate. But, you know, often executors will bring beneficiaries into conferences with lawyers like myself, and sometimes the duty of the executor and what we advise the executor can be contrary to what the beneficiary might want, because when the executor or administrator seeks legal advice, they are the client and they act on behalf of the deceased estate. So the lawyers and the accountant's obligations and duties is to advise the executor as to what their obligations and their duties are. And, you know, even though we act for the executor or the administrator, they represent the estate. So the advice is often what they should do, how to protect themselves, and what they should do in the best interest of the estate. Other issues that can arise may be dealing with asset holders. So some asset holders, such as banks or land title brokers, they may have difficult requirements, particularly if they're not one of the big players who often have these kind of matters. Issues can arise if the executor if the deceased had assets overseas, or if the deceased had encumbrances on their assets, such as, you know, there's a caveat or there's a mortgage on the asset, or, you know, loans on the asset that needs to be dealt with. So as part of the administration process is to deal with all those issues. It's not just collect the assets and then distribute it in accordance with the will to the beneficiaries. There may be issues that the executive and administrator need to deal with. There may be issues with creditors and debtors. I think one of the things to remember is that a deceased estate can sue, so the executor can sue another party on behalf of the estate, and that the estate can be sued by third parties. And then if they are sued, it is then up to the executive to give instructions to solicitors to defend any proceedings. Other issues may arise, such as taxes and duties. Sometimes the deceased hasn't lodged their tax returns for a number of years, so the executive administrator would need to seek accounting and financial advice in order to close off and finalise all of those affairs. There may be issues with renunciations or consent, particularly if there's an issue with the will and the court requires consent from other interested parties, such as beneficiaries, in order to issue either a grant of probate or a grant of letter of administration to the executor, the administrator, or the applicant. There may be issues where there are minor beneficiaries. Executives and administrators need to be aware of their obligations when there are minor beneficiaries involved in an estate, or if there is a will where they've set up particular trusts, such as special disability trusts or guardianship funds or discretionary testamentary trusts in the will, and advice needs to be obtained in order to understand in order for the executive or the administrator to understand what it is that they need to do, how they manage the trust, how they set up the trust, and what kind of responsibilities and obligations they have in terms of the trust that has been set up in the will that the deceased has left behind. Sometimes, if there is a will or if there's no will and it's intestacy and everybody is in agreement about how to distribute the estate or to distribute this estate in a manner different to the will, they can enter into what's referred to as the deed of family arrangement, and that's part of the administration process as well, and part of the executive and the administrator's role to coordinate everyone and get their consent to this agreement because it affects their interests. So all the above that I've mentioned are issues that can arise in a deceased estate when an executor or administrator administrator is managing the estate. And often these issues are not apparent at the very beginning. They're not identified until we do some inquiries and we make we contact other beneficiaries or we read the will. So most of these issues are not identified on the onset. Ideally, you're like to identify them so you know what you are up for if you are the executor and you're thinking of taking on the appointment. One of the other things to remember is that accounting to the beneficiary is a very important role of the executor as well, because the beneficiaries are the ones who will be entitled to the estate. So anything that would affect their interest is strongly recommended that you seek their consent or to seek their consent or to seek their input. Now, they're not entitled to make the decision, but because it affects them as the executive administrator, if you've got consent to a particular action or a decision that protects you from any potential future claims in the future in terms of administering the estate. I think the only other thing is to remember is that when someone passes away, the first thing that people should do is to bury the deceased or to arrange the funeral. And you don't necessarily need a grant of probate or the will to arrange the funeral or to cremate or bury someone. Often the family would make that decision and the wishes of the family are respected. The will is produced and a grant of probate is obtained if there is a dispute in relation to how the deceased is buried or how the deceased is buried or whether the deceased is buried or whether they've been cremated or not. When there is a dispute, it is the executor who has the final decision. If there's no will and no executor, then often it's the senior next of kin who will have that decision. But that's only in a matter of where there is a dispute as to how to deal with the body of the deceased. And you can put your burial wishes in your will, and if it's in your will, then it's often followed, and the executor will make sure that your wishes are followed in your will. But that's just to keep in mind that, these disputes do arise. Disputes, you think that burying someone is quite straightforward, but there are matters or cases where a dispute can arise in relation to where to bury someone or how to bury someone. So there are things that executive administrators can do before obtaining a grant of probate or getting the will out and reading the will. And reading the will, that brings me to, in Australia, there's no formal requirement to read the will. There's no formal requirement to have a meeting and read the will to all the beneficiaries or the family. There's no requirement that the executor provides copies of the will to the beneficiaries, but there is a requirement under the relevant Wills Act in each of the jurisdictions that there's a whole category of people who are entitled to a copy of the will if they request it. So you don't need to volunteer the document, but if it's requested, then they are entitled to a copy under the relevant Wills Act in each state and territory. I think that's all I have to say. I think the only thing that I would like you to take away from this is, again, if you're ever appointed an executor of a deceased estate, the first thing you should do is obtain legal advice. This session was designed to give you some basic information so that you know what's involved when someone passed away, what needs to be done, the process, the estimated time frame, so that you have an understanding of what's involved in the process. But every single case is different, and there are often not two cases that are identical. They may be similar, but they are very often different. So it's important to get that advice on the onset, particularly if you are not wanting to be taking on your appointment as the administrator of the deceased estate. The other thing I probably wanted to mention is we talked about grants of probate and grants of letters of administration with the will or without a will. And the other thing to keep in mind is that sometimes you may need to obtain what's called a grant of resale. So a resale of a grant is where a deceased has assets in more than one jurisdiction, such as if somebody had assets in New South Wales and the ACT, because the law regarding deceased estate are governed by different states and different laws. If you would need to obtain a grant in one jurisdiction and then get that grant resealed in the other jurisdiction with the other assets they have. So if the deceased had assets in all the jurisdictions like Victoria, New South Wales, Queensland or South Australia, then it makes the estate more complex and you do need to obtain a reseal of the grant in all of those jurisdictions in order to deal with the assets in each of those different states and territory. And that's something that your solicitor would be able to assist you with and advise you in relation to, and those kind of steps and processes do add to the time frame in administering the estate, and that can, because these processes do take a bit of time. And I think that's all I have to say. If you have any questions, feel free to contact Chamberlains.